Now let's see what happens when you refuse to perform, when the promiser says he'll not perform. Let's see what are the rights of aggrieved parties. Now I'll just give you an example. There are two persons, X and Y. X contracts to sell 100 bags of cotton to Y, and Y in turn tells him that he'll pay him 1 lakh rupees. So this is the contract that we have on our hands now. Now let's say X has delivered 100 bags of cotton to Y, but Y refuses to pay 1 lakh rupees. So now X is the aggrieved party, he is the victim party. Y did not perform the contract, so X becomes the aggrieved party. Now let's see what are the rights of such an aggrieved party. First is he can terminate the contract anytime once the performance is refused. Now if you'll ask me, what is the need to terminate the contract? Y is anyway not performing, X has anyway performed it. So what is the use of cancelling the contract, because X has performed the contract already? The use of terminating the contract, rescinding the contract, cancelling the contract is that now once X cancels the contract, he gets the right to ask his 100 bags of cotton back. If the cotton has already been used, then he can ask for compensation. That is amount equivalent to 100 bags. So this is the use of cancelling the contract, because unless he cancels the contract, he cannot demand the goods back. Only when he cancels the contract can he demand the goods back. So it is important on his part that even though he has performed the contract, even though he has performed what he had promised, he cancels the contract, because unless he cancels the contract, he cannot ask the goods back from Y, because he's refused to perform. Since he's refused to perform, it is now X's right that he gets the goods back, but he'll get this right only when he resigns the contract or terminates the contract or cancels the contract. The second option that he has is to wait for X to perform, is to wait for Y to perform, even though Y has refused to perform. Y said he'll not perform. So now what is X doing? X is saying, I'll wait, I'll continue with the contract, and I'll see in the near time if Y performs or no. He's giving Y some time to perform. He does not want to jump into cancelling the contract, because it is very important for him to get the money. Even if he gets the money late, he's okay with it, but he wants the money dearly. So he waits for Y to get into a better financial position and pay him the money. So he has two options. First, to cancel the contract, terminate the contract there and then. Second, to give Y some time and continue with the contract. His next right is claim compensation. Now, claiming compensation can come only after termination, because if he has chosen to continue with the contract, he cannot claim compensation, because he himself has agreed to give Y some time. So he cannot say that he wants compensation because he's waiting for Y to complete the contract. He's waiting for Y to perform or to do his side of performance. He himself has given him time. So he cannot ask for compensation until and unless it is established that the contract has been cancelled. So he can claim compensation only after choosing to terminate the contract. Before terminating the contract, the question of compensation does not arise. So if he wants to claim compensation, it is very important that he terminates the contract. This is the importance of termination of contract. Nowadays, to terminate the contract, he has to file a suit of rescission, a suit of termination. And once the suit of termination is admitted, it is established that Y has refused to perform, the contract is cancelled by X. Only then X can file a suit for damages or compensation. But nowadays, both the suits are filed together. The suit for cancellation of the contract as well as the suit for compensation is filed together. Both the suits are filed together. Please bear in mind that once he chooses any of the options, that is, if he chooses to terminate, the contract, that should be final. After that, he cannot reverse his choice. Let's say he files a suit of termination in the court. The court admits the suit, allows him to terminate the contract, and then after a week he cannot go to the court and say, I am taking my termination back. No. If he chooses to terminate, that is fine.